When the issue of Hillary Clinton and her email issue crops up, we often hear the words, she may have broken the letter of the law, but she did not break the spirit of the law. Or it could even be, she didn't break the spirit, but maybe she broke the letter. Honestly, it is confusing. You understand. Most Americans would simply just listen to all this and say, what's the difference? Is not breaking the law something of an absolute? All right, let's dig into this part of the conversation. Welcome to MidPoint, a former high-ranking official at the Justice Department. He was the founding director of the DOJ Office of Information and Privacy. Now a law professor at American University, Dan Metcalfe joins us. Professor, thank you so much for being here today.
Pleased to be with you, Ed. Good afternoon.
Good afternoon. Professor, I think I put it simply because people will always hear these things back and forth. The letter was broken, the spirit was broken. All right, simply put, from a legal standpoint, did the former Secretary of State break the law?
Well, the first thing I should probably emphasize is that when people think of the law being broken, they think of a criminal statute. In other words, a crime having been committed for which they could be prosecuted with criminal penalties. That's not all of the law. I know of no basis for imagining that there was a criminal statute violated in this case. I'm not an expert on criminal law, so I'll just leave it go at that. But then there's also civil law, legal requirements that are placed on people for which the penalty for noncompliance can be a broad range. Civil penalties, paying money, and even sanctions if you're still a federal employee. In this case, the quote-unquote laws we're talking about are first the Federal Records Act, and secondly the Freedom of Information Act. And in my judgment, based upon the facts as they are even admitted by Secretary Clinton, she did indeed violate the Federal Records Act and blatantly circumvented the Freedom of Information Act with what she did and didn't do.
I think it's interesting because in an article that you wrote in Politico, there were a couple of things that caught my attention. But first of all, right up the front, it talks about you weathered a lot of Clinton record scandals during the 90s. You thought you'd seen the last of them. You thought you had become immune to being shocked by anything. It turns out you were wrong. Why is that?
Well, the first part of that is that, yes, indeed, there were about 24 quote-unquote scandals during the Clinton years that involved record disclosure issues. You know, when something goes wrong or is a matter of heightened public scrutiny, as a controversy, let's use that word, there are invariably records pertaining to that. And then the question becomes, which of those records, which portions of them, if any, will be disclosed to the public to address public concern? And that's where my office came in. We worked on the information disclosure policy questions surrounding those matters, and help the White House and other federal agencies, where applicable, make decisions as to what should be disclosed to the public and what should not.
Professor, were you correctly quoted when you called Mrs. Clinton's email system laughable?
I was correctly quoted, but let me hasten to emphasize that the full quote was that what she established with a personal email account and then a private server, and her saying that that was adequate or sufficient under the law, including in the face of Freedom of Information Act requests, that suggestion is indeed laughable. So the elements of that formulation are the personal email account, the private server, and in face of Freedom of Information Act requests.
I've only got about a minute left here, but you mentioned the Freedom of Information Act. Is that just a phony line these days? Is that just a convenient line people toss around and it has no meat to it anymore?
Well, I worked my entire federal career, at least for 30 years, with the Freedom of Information Act, and I would dare say it has a lot of meat to it. There are concerns certainly with agency backlogs and the time delays in responding to the Freedom of Information Act requests, but it's a quite potent law indeed. And in this case, I have no doubt personally that Secretary Clinton was quite familiar with the Freedom of Information Act based upon what happened in the 1990s, and she blatantly circumvented it.
I have about 20 seconds left. Do you think the Department of Justice will honestly get to the bottom of this?
It's not the Justice Department's responsibility to do so. I think there's a chance of an Inspector General investigation within the Department of State. I think there's a chance that the National Archives and Records Administration, which administers the Federal Records Act, will look into it and act accordingly. And there's always the chance that there'll be further scrutiny on Capitol Hill.
It is not over by any stretch of the imagination, but it is always good to get the actual, real legalese of what is going on here. Professor Dan Metcalfe, a fascinating article. I thank you so much for joining us.
Pleased to be with you.
Pleasure. Take care. The pictures of a man being arrested and bloodied, police brutality, or another story immediately taken out of context to fit a narrative. We'll have that and more when we continue here on MidPoint.